and I reserve all my rights before I cross this bar.
Sure. Let the record reflect that you are a living man, because dead men cannot speak. So, and I can hear you
This fraudulent presumed anyways, though.
Alright. So, this is people of the state of Michigan versus Eric and Martin. Today's date and time set for a pretrial in this matter. Are there any issues that need to be brought or raised before the court?
Excuse me if I may at first. Mr. Martin indicated he did not want me as his attorney, so I'm asking for permission to withdraw.
I had, first off, Mr. Martin, I had previously appointed Mr. Gazicki as your house counsel. Mr. Gazicki has made a statement that you do not want, you have indicated to him that you do not wish for him to be your attorney. Is that correct?
Yes, and not just him, any attorney, because I will not be allowing attorney to turn me over to the court, the jurisdictional court, which is what they do. This is why I don't set them normally.
All right. So you want to represent yourself, is what you're saying?
Not represent myself, but present myself.
Present yourself, represent yourself, same thing, sir. Again, we're not going to play semantics like you did the other day.
Yep.
So
the law is based on
it's the same thing, sir. It's the same thing, literally the same thing. Look at the thesaurus, present, represent, sure. All right, so the motion's granted. You can withdraw, sir, Mr. Gazicki, and Mr. Martin, you'll be presenting and or representing yourself in this matter, because you have a constitutional right to do so, and you can. So, today's the date and time set for a pretrial. So, Ms. Sobe, you have not had the opportunity or chance to speak with Mr. Martin, who is improper. Is that correct?
That's correct, Judge.
All right, so I'll allow the two of you. I will set this case over and I'll let you two discuss the matter in the hallway or in your office, and then I'll recall the case after you guys have had a chance to pre-trial the matter.
Before we get into that, Judge,
Sure.
I do want to put on the record that my victim's advocate, Ms. Delisha, has been in contact with the complaining victim in this case at great length, and there is a no contact order. The victim is the brother of the defendant in this case, and he's notified us that he is still living in the same house. So the defendant and the victim are living in the same house, even though there's a no contact order. Further, the complaining witness has indicated to us that he's being threatened by the defendant in his own home, once again violating that no contact.
All right, guys. Today we're diving straight into chaos as the hearing opens mid-meltdown. No warm-up, no filter. The defendant instantly announces he doesn't represent himself, he presents himself, like that magic word changes reality. His lawyer tries to quit on the spot, which already tells you this case is radioactive. The judge doesn't flinch. Within seconds, it's clear this won't be a legal defense. It's going to be a showdown between fantasy law and real authority, and that rarely ends well.
To my knowledge, is in the hospital at this time. He's unable to zoom in, even though he wanted to be here.
He's in the check-in room right now.
He's been attempting to, but he is in the hospital, could not be here in person. He might have audio.
I think they're in the, I don't know what this thing is. I got Kurt Martin
Yes.
in the check-in room. So if you want to zoom back in, or if you jump in back in on Zoom, Kurt Martin is in the check-in room right now.
Yes, the people just wanted to bring that to the court's attention, the multiple violations of the no contact order, the living in the house and the threatening and speaking to the complaining witness.
All right, so sir, are you still living in the same house with the victim?
I object to that question as violating my right against self-incrimination, so I will not be answering that question based on that. And also I want to object to her what she just mentioned. First, I want to mention allegations that I'm there. That's not sufficient evidence that I actually am there. And number two,
I'll just have a bond hearing, is what I'm saying.
Well,
and then everybody will be sworn in and all that kind of stuff. Because I've already given you bond conditions. Part of those bond conditions was that there should be no contact with the victim. If you're living in the same house with the victim, you need to go somewhere else.
Well, first of all, he ain't a true victim. That's something I'm object to. First of all,
first off, listen, you're not going to. I'm not even going to entertain any of your stuff. This internet, Google the internet type stuff that isn't even real or true. All right, I've already ruled on most of your motions, and I'm going to let you rule. I'm going to let you bring your motions again. And I'm going to make rulings on them. But what I'm saying is, you don't have a choice in the matter. I gave you bond conditions. They're alleging that you violated the bond conditions. So under the Constitution, I can't just say, oh, you're in violation. No, I need to have a bond violation hearing. And if you are in violation of my bond conditions, then I can hold you in contempt. If you're not, then you're not, and the case just goes forward. It's as simple as that. It's called due process. So what I'm saying is, when she says you object, when you say you object to the alleged violations that she's alleging, listen, you don't even get a chance to object to that. That's their job that's their job to bring those. And if they're correct, they're correct. If they're not correct, you have the right to have a bond hearing. And at that bond hearing, if it gets proven by a preponderance of the evidence that it is true that you violated my bond conditions, then I will proceed accordingly. And if not, then the case will just go forward and you'll still have all your constitutional rights. So what I'm saying is your objection is overruled because there is no objection that can be made to allegations, because that's all they are, is allegations.
So objection made based on the Constitution. There's no sufficient evidence.
Buckle up, guys, because this is where the case turns from weird into dangerous. The prosecutor calmly drops the bombshell. The defendant is still living with the alleged victim and making threats despite a no-contact order. That's not a misunderstanding. That's a direct violation. While the defendant pretends it's just paperwork, the judge instantly shifts gears toward consequences. This is no longer theory. This is real risk, real harm, and real legal trouble stacking up in real time.
You're not going to testify. You're not going to testify. Listen, you're not going to testify. If you want to testify at your bond violation hearing, you can do so, or you have the right to remain silent. Anything you say can and will be used against you. So what I'm saying is, the only reason I'm cutting you off because I don't want you to step on your own constitutional toes. Everything you're saying could be used against you. So I don't want you to say something that you didn't mean to say, and then all of a sudden, then they get to use that against you, because that's your right to remain silent. You understand that, right? You understand what I'm saying? Okay, I'll take your silence. I'll take your silence as an affirmative.
No.
So, well, you didn't say that you didn't understand. So
no, I do not understand.
You don't understand.
I stand under anything you're saying. So, but anyways, this discussion for emotions
from an English standpoint. You're not standing under anything. I didn't build a bridge. I didn't build
legally it's not all
I
based
didn't put up an umbrella. I didn't put up a canopy. I didn't put up any kind of other item that you could stand under, a ladder, you name it. So there's nothing that I've said that you can stand under. But what I am saying is you do have the right to remain silent, and anything you say can and will be used against you at trial. So that being said, I'll let you go into the hallway. You can meet with Ms. Stowe and have a pretrial in this matter, and then we'll deal with after Kurt talks with the victim advocate, and then you talk with the victim advocate. We'll decide when we're going to have the violation of the bond condition hearing.
Thank you, Judge.
So I'll remind you, this is scheduled for a motions hearing, and
So the two of you can go out and have your pretrial.
My demand.
I just told you go out and have a hallway, have a pretrial. If you don't want to talk to her, then don't talk to her. That's up to you. But what I'm saying is right now.
Okay, I'll talk to her. What I'm saying, but right now I have these.
Sure, you're not controlling these proceedings. I said right now is the time for you and Ms. Stowe to have a pretrial. If you're going to have a pretrial, we'll do that. I'll control when cases get called in front of my court. Thank you very much.
All right, guys. Now you're watching the moment authority finally slams the brakes. The defendant tries to object. His way out of danger like this is a game show buzzer. The judge shuts it down hard and explains exactly what due process looks like when it's not just a buzzword. You can hear the frustration in his voice. Not angry, just tired of nonsense. This isn't a debate club. This is a courtroom, and the judge makes something painfully clear. Reality runs this hearing, not Google law.
Dismiss the case for lack of jurisdiction is denied. 1, you live in Taylor. 2, you allegedly committed a crime in Taylor. 3, the complaint was filed here in Taylor and was sworn to here in Taylor. So under that Constitution, you have availed yourself of the jurisdiction. You live in Taylor. You enjoy all the protections of the police department, the fire department, garbage services, you name it. You have more than adequate minimum contacts with the jurisdiction, and I find that your motion has no merit. It is denied.
I don't object to that. As my argument, Article 3, Section 2 of the U.S. Constitution, that's totally irrelevant to when a state's a party. This court doesn't have original jurisdiction. Only the U.S. Supreme Court has original jurisdiction on Article 3, Section 2. And Article 3, Section 2 doesn't allow them as reasons to deny or to say that you do have jurisdiction. They do not allow it.
Sure, Article 3, Section
Therefore, they
2.
allow your denial of my amendment.
Again, your motion is denied. Article 3, Section 2 of the United States Constitution deals with when one state sues another state. And that's like trash cases like New York versus New Jersey, things like that. But they have original jurisdiction over those cases. This is the state of Michigan versus an individual who lives here in Michigan, and that's you. And so living man, living trust, living Stewie, whatever you want to call yourself, guy, big E, little G, I don't know, whatever, all that good stuff, big M. None of that makes any sense, nor does it make any difference legally. The fact that I have little yellow tassels around the flag over here, that doesn't change anything either. This is the United States. Sure, keep on mumbling. This is the United States. This is Taylor. You live in Taylor. You committed a crime allegedly in Taylor. So the case is going to start here in Taylor. And so that's why I have jurisdiction over you for the reasons stated on the record. And just the obvious, the United States Constitution and Michigan Constitution, I have jurisdiction over this case. So that motion.
Buckle up, because now we enter sovereign citizen fantasy land. The defendant claims the court has no jurisdiction, pointing at the Constitution like it's a cheat code. But the judge calmly dismantles it line by line, explaining that living in the city, committing a crime there, and enjoying its services gives the court power, period. No legal circles to walk in, no mystical wording, just facts. This is the moment where ideology crashes straight into infrastructure and loses.
The ones who specifically state that I can set bond conditions in order to do a couple of things. One, to make sure that you appear at court. Two, to make sure that there's a difference between the parties or allegations of violence against the parties or between the parties, that I can keep the two parties separated in time. So you need to be not living in the same place as the victim in this matter. Now, at the bond hearing, I'm going to set a bond hearing for the alleged violations of that bond hearing, because one of the things I need to know is who owns the house, like legally owns the house. Because I'm a big proponent of property rights, and that was one of the biggest things that we moved over here and created a constitution, and why property rights, and you can't just take people's property and all that kind of good stuff. So somebody's going to be moving out in the meantime during the trial. I don't know if it's you or if it's a victim. Whoever actually owns, like owns the house. I'm not going to order somebody to move out of their own house and let a victim or alleged victim stay in a house that they don't even own. The victim will move. That's how that's going to work. So if you want to check with the victims and see who actually owns
To
the
my
house.
knowledge, I believe it is the mother's house,
Okay.
and they are brothers.
And the mother is still
With-
alive?
To my knowledge.
Okay.
Is she alive?
You talking about my sister, Lisa Martin? No, she always keeps saying she owns it. She don't own nothing.
Who owns the home?
Well,
I'll
this is
just
the
look up,
thing.
I'll just look up the Wayne County Register of Deeds. Council, just make sure you just do a search in the Wayne County Register of Deeds, find out who owns the home.
Well, under adverse, non-adverse possession law, because I've been living there a minimum of 15 years under that state statute.
No, you see, again,
I am-
listen. You just have no law, but I literally teach it. So just telling you, you're wrong, because you can't have adverse possession with permission. If you have permissive use of the property, you'll never, ever gonna get adverse possession.
Adverse or non-adverse, okay?
Okay, there is no non-adverse, trust me. I don't remember that one ever being on the bar exam. You know what, hey, whatever bar exam you wanna take, you let me know, I'll study for that.
All right, guys, welcome to the property debate from another dimension. Now the defendant claims he owns the house, not with deeds, not with records, but with vibes and YouTube logic. He doesn't even know who holds the title, yet insists possession equals ownership. The judge calmly schools him in real property law. Permission to live, there is not ownership, and mortgages don't erase deeds. The fantasy continues, but the law refuses to play along.
And you always want to try to.
But no, because I want to wait till everybody's under
Being
oath.
fair.
I'm just saying, I'm staying at the hearing. I want to know legally who owns the property.
No, someone's mentioned, no, we can do that too. I'm just saying, but it's always,
Oh, we're not ready to do that now
Parents' house.
today.
Justin, it was always my parents, right? House, so to say, and I don't even think they really owned it because the mortgage wasn't paid off. So I don't think really, no one totally owns
A
it.
mortgage
It's
is just a
paid.
promise to pay money. It has nothing to do with actual ownership. Ownership and mortgage are two different things.
I think actually, all of us at the house are possessors of law. My understanding of law is we're actually possessors. because the bank really owns, because the mortgage was never paid off, from my understanding. But it was always, so to say, her parents' house, like I said, I don't think they really owned it.
Sir, here's what I'm gonna do. I'm just gonna go ahead and sua sponte, look it up in the Wayne County Register of Deeds myself, because it's a matter of public knowledge. And then I'll take judicial notice of the fact who's the owner.
Like I said,
That's all I gotta do.
the verse and non-verse possession, MCL
So-
statute.
What we're gonna do is we're gonna have a hearing date. And that hearing date is gonna be on the same date as the jury trial. So in the meantime,
I have a right to be there though, because I've been there minimum
did it say
15
you,
years.
I
By
mean,
the
you
state
don't have a
statute.
right to be there, so you don't own the
Sure.
property. You don't own the property.
Under that statute, I am.
You don't own the property. So you need to vacate the premises, because that's where the victim lives. I told you no contact with the victim.
And that's an unlawful void order because it violates.
But
the
it's
law.
not, because I
Because
just
without
said.
any evidence, you can't just say, I can't be
Okay,
at a
so,
house.
listen, sir, I'm gonna tell you one more time. I'm not gonna sit here and argue with you. If you keep arguing with me in court here, I'm gonna hold you in contempt, because you're just holding up everybody else who's ready to go and proceed with their cases. And you just keep bringing up the same thing that isn't anything at all to bring up. I've already rated my ruling on your motion, I've denied your motion. I told you that you can't live in the same house with the victim on a domestic violence case, when I told you you have no contact with the victim. And if you don't own the house, now if you own the house, like actually own the house, like show me the deed that shows that you are the Wayne County Register of Deeds, that you're the owner, I'll make the victim move. Why? Because I'm not gonna kick somebody out of their own house. I'll make somebody will move, but it ain't gonna be you then. But you don't own the house. Okay, so, you're gonna need
And I
to
have
vacate the
objections to that.
premises.
I have
You're gonna need to
objections that.
vacate the premises.
Okay, and I objected, like I said, it's not just a deed whether someone owns it. Under the statute in Michigan, it mentions.
First off, what statute? Cite the statute.
Okay, I don't have it right in here because I
Oh,
was
well.
going to grades, but I'll give you the statute. You already know me. I cite MCLs all I know from, so I'm gonna give the MCL statute, but it deals with what's called non-adverse or adverse possession, okay? So if you live,
Well aware.
one of the basic elements, you lived at a house for 15 years, right? Remember, this is my parents' house, right? I've been there 30-something years. When you lived in a house that long, you are considered part owner at least, if, you know, so, and therefore a right to.
Buckle up, because this is where patience runs out and consequences walk in. The judge draws a hard line. You don't own the house, you will leave. The defendant keeps arguing, and the judge finally warns him. Continue, and you're getting contempt charges. Jail and fines are no longer theoretical. They are on the table. This is the sound of authority being fully asserted. And for the first time, you can tell the defendant realizes words aren't working anymore.
A deed or not, that's, and regardless of the ownership
No,
issue, yes.
No,
No, okay,
you have a
MCL statute, I'm
possessory,
gonna cite
after
you.
30 days, if you stay in a premises with permission, after 30 days, you become a de facto month-to-month leaser. And you become a leasee at that point, and you have a lease with the property. That's it, at best. And that means you can stay there and they can evict you, or I can give you a bond order that says you need to vacate the premises.
Yes, if
That's a
someone
court order.
owns it, maybe, yeah, but.
You don't own it. You don't get a possessory interest, but you don't get an ownership interest. There's an
No,
absolute
like I said,
difference.
no one owns it.
There's an
because-
absolute difference. Listen, you're not gonna argue with me. Keep arguing with me, and I'm gonna hold you in contempt. Because I'm telling you, you don't own the property. You have a possessory interest at best, because you've been there for 30 days, sure. And they can either evict you, or a bond condition can move you out. Either one. Or actually, an injunction from the circuit court for if there was a case, they have the power to move you out of there as well. There's 3 different scenarios where you could be moved out of there. One of them is bond condition. Bond condition says no contact with the victim. You don't own the house, get out. In the meantime, get out until the case is done. So if I find or know that you are there, I'm just telling you, I will hold you in contempt of court. I will remind you that contempt of court is a misdemeanor punishable by 90 days in jail and or up to $1,000 in fines. And I'm just going to let you make sure that you are aware of that. Again, ask you, would you like any court-appointed attorney to help you in this case?
No.
Okay,
I have
just
more
double
to say
checking.
now. And
Just
it's also
double checking.
said, part of my constitutional rights.
Just
No.
double checking.
The order, first of
So-
all, the bond order violates my due process because you can't tell me to be out of the house, my house I've been living in all my life.
It is because it's not your house. You keep saying your house and it's not your house. It's the place that you were allowed to stay by your mom and daddy. But now they're no longer, this is not that situation anymore.
The
It's
statute
not that
does.
situation anymore. So you don't.
All right, guys, this is the courtroom execution, legally speaking. Every motion collapses. Jurisdiction denied. Bond challenge denied. Standing argument destroyed. The prosecutor's authority upheld. The judge doesn't raise his voice. He doesn't need to. He just applies law like gravity. And just like gravity, it doesn't care who thinks they're special. A trial date is set. The fantasy ends. Reality wins. If you enjoyed this breakdown, hit like, subscribe for more courtroom chaos, and we'll see you in the next video.